Thank you. It's 10:15. We can resume the hearing there. Mr. Scott, are we all sorted on the technical side?
So I think it's the best we can do at the moment. I'm not quite sure. I'm told that they're working on it on the other side, so I think it's probably best to just proceed.
Are people able to, on the live feed, see and hear us? Or is there some continuing difficulty with that, is there, as I understand?
I know that there's technical people trying to get us live now, so yeah.
I'm mindful that this is a public inquiry.
Okay. I have approved. I have confirmation that we're live, so that's good. Yeah. Okay.
I was only going to say that there may well be people who are actually interested in the proceedings, so I'd rather they were included rather than excluded. If we needed to delay for technical issues, we could have done that. As you can draw breath before giving your evidence, I'm pleased I'm not the only one wearing many hats today. I'm to draw it all, but if you're happy to proceed. Yep, okay, thank you, Mr. Henderson. Over to you.
Mr. Stroll, I'll start by introducing you, please. So your proof of evidence, and we'll look at paragraph 1 of that document, please. And you tell us, so that's paragraph 1, which is on your page 2, you tell us that your name is Sean Scott, you've got qualifications, BSc in Geography and Environmental Management, and an MA in Urban and Regional Planning. You're also a chartered member of the RTPI. You have over 14 years of experience in town planning work for local authorities in the private sector. You're presently a Principal Planning Officer for Maidstone Borough Council, and for the past 8 years you've advised on and determined applications for major developments, mainly large-scale housing and commercial developments. You also explain in your paragraph 3 that you were the chase officer for the application, and you're familiar with the appeal site and the surrounding area, which you visited on a number of occasions. And then in paragraph 7 we get your professional declaration. Is all of that correct?
Yes, that's correct.
Thank you. Okay, so the first topic we need to deal with in your evidence, please, is the allocation in the local plan reviews. Can I ask you to go forward, please, to your paragraph 31, which is on, it starts on page 7 at the bottom of your evidence.
Yeah.
And you deal with the context. So firstly, can you place the allocation in its policy context, please?
Okay, so Yalding, under LPR SS1 is a larger village, and SS1 identifies this area as larger villages as suitable for limited housing development only, and Yalding, it sits 5th out of 6 settlement areas identified for growth. With Maidstone Maidstone urban area being the focus of development. The scale of development is to be consistent with the scale and role of the village. That's the sort of main message out of that.
And what does that mean in terms of Yalding then?
So Yalding is included for a limited amount of housing development, essentially.
Right. And what's the reasoning behind that as an approach?
Well, the area is it's got a good. It's in the setting of the LLV, but it's also got the countryside character, and it's so yeah. It's mainly because of the outstanding characteristics of the area in terms of its countryside location and its the LLV. And when I say countryside location, I mean on the edge of the countryside.
Right. With that context in mind, can I ask you to turn forward, please, to your paragraph 35, which you see on your page 10. And in paragraph 35, in a number of subparagraphs, you repeat and refer to the approach to the allocation which the council set out in the statement of case that we've all seen. But from your perspective, what are the key issues as a matter of approach which arise for consideration when you're looking at the allocation?
So you mean the site allocation, right?
Yeah.
Yeah.
Policy LPA SA 248.
Yeah. Okay. So the main thing for me is to look at the first part of that condition of the policy, which it explains is for approximately 100 units and also 30 a density of 30 dwellings per hectare. This sort of sets the scene for the rest of it, which it follows that there are a number of conditions with the main things that are standing out in the assessment of this application being the LLV and the need for an LVIA assessment and providing things like the internal landscaping structure. So those are the things that I've sort of assessed primarily.
Right. I want to look at a number of points that arise from that. So you've referred in your answer a moment ago to paragraph 1 of the allocation, which is at the bottom of your page 9. You've reproduced it there. The question I want to ask you is about the word approximately as it appears there, and it does so in two different locations. Firstly, before the words 30 dwellings, so approximately 30 dwellings, approximately 100 dwellings, and then secondly, before 30 dwellings per hectare, so again, approximately 30 dwellings per hectare. Now, the case put by the appellant, it's in their opening, is when one reads the word approximately, that's an approximate minimum. I'd like your response to that, please. Is that an approach you agree with?
No. So approximate to me is regarded to mean means come close to or come near to something. It's not the case that approximate can be at least. So for me, approximate can be above or below the unit numbers or density ranges, provided that they come close to that.
Now, in that context, one of the points made by Mr. Ross is by reference to LPRSS1. Probably worth pulling that up so you've got it in front of you. So that's CD 2.1, the local plan review. Within that, if you go please to page 33, you'll see at the bottom of that page LPRSS1. And in paragraph 1 of that policy, I'll read the whole paragraph. Between 2021 and 2038, provision is made for the granting of planning permissions and the allocation of sites for a minimum of 19,669 new dwellings, and that's expressed as a minimum. Does the fact that the housing requirement here, does the fact that that is expressed as a minimum have any consequence in your view for how you approach the words approximately in the allocation?
Yeah, so minimums are set out by SS1 at 19,669 dwellings across the whole borough. And this is purely related to need. We're talking about a local plan review in the early stages, and over time, there is every possibility that this will level out over the plan period because some sites will deliver above or below within an approximate number. The amount of land allocated is a significant boost to what there was before within the new local plan review. And there is an expectation that the sites, that there is no expectation, that the sites would be under-delivering, as the expectation would be that they optimise their density.
Right. So in light of that, does that lead you to conclude that approximately should mean approximate minimum or not?
No, I wouldn't agree with that.
Right. The other point that's made is by reference to policy SP10. So can I ask you to go there, same document, CD 2.1, Policy SP10 is on page 132 at the start, under the subheading Housing Delivery, or the title, sorry, Housing Delivery. Paragraph 1 of that policy repeats the number that we've just been looking at, but if you go forward please to paragraph 7, so 2 pages further forward, page 134 at the top, paragraph 7 of the policy, under the subheading Designated Neighbourhood Areas, as a minimum and as set out in the table below in the supporting text, designated neighbourhood areas are required to accommodate housing from any site allocations within their designated neighbourhood area boundary or part thereof, as contained in Section 8 in Appendix 1 of the LPR, plus any additional homes assigned to them through Policy LPR SP 8, smaller villages where relevant. Additional to this are windfall sites, including first homes, affordable housing exception and older people's housing sites, and any part of the garden settlements or strategic development locations that fall within the designated neighbourhood area. And then paragraph 8 below that, any future designated neighbourhood areas will be expected to accommodate as a minimum relevant housing requirements from Part A site allocations in the LPR. And then we see over the page, 2 pages over, the table starts at page 135, and then on the second of those pages, 136, we see Yalding at the bottom, because that is a designated neighbourhood plan area, and 100. So, first question to you, Mr. Scott, is does policy SP10 and the provisions in paragraphs 7 and 8 that we've just looked at, does that indicate that the word approximately should be read as an approximate minimum in your view?
No, it shouldn't. So policy SP10, as we've mentioned, deals with neighbourhood plan areas. Should a plan come forward, so that's a neighbourhood plan come forward, it sits separately to the allocation, and it's intended to make sure that the neighbourhood plan tackles housing allocations, should it choose to do so in a way that's compatible with the LPR. In this instance, it's saying you can't drop below 100 units. It's not about the site, and the neighbourhood plan does not have the ability to rewrite the site allocation.
So that's the first issue in terms of the allocation and what the word approximately means. Let's turn then to apply that, please. So the issue here is whether 112 dwellings at 33.4 dph is approximately 100 at 30 dph. What's your view on that, please?
So 110 units, 112 units is not approximate to 100, being 12% higher, and at a density of 33.4, that's 10% higher. This is not considered to be approximate. It's important to consider the context in this scenario, and the way that the local plan all the way through has a approach to limited development of these larger villages, and this is clearly outlined at LPR SP7 and in other areas throughout the plan.
So as a result of that limited approach, what does that mean for the way you approach the approximation here?
Limited growth.
Right. So that's topic 1 then in terms of the allocation as a matter of approach. But let's turn now, please, topic 2, the history of the allocation. Don't want to do too much archaeology, but it is referenced in a number of places. So let's start with the SHLAR, please. CD 3.1.2. And this is Appendix A to the SHLAR. And help me, when does the SHLAR date from, Mr. Scott?
Okay.
Oh, right. So in terms of SHLAR, we know that we've got this from 2021, so that's 3.1.1. We're looking now at 3.1.2. Appendix A to that document. The relevant page for our purposes is 423 in the PDF, so PDF 423. Let's have a look at that, please.
Yeah.
Mr. Strott. We've got a number of things to unpack here. The first is the nominated capacity, 165 units. What's that referring to?
So my understanding is that that relates to the entirety of the site. We're talking about an area of 9.93 hectares.
And when it says nominated by who?
Well, by the developer, by the applicant, Hallam Land Management.
Yeah. And then a model capacity, 160 units. Explain what that is, please.
The modelled capacity, so that is referring to that site area 9.93.
Right, and modelled by who?
So essentially, this is a broad brush approach, considering both sides of the site. So that's the only comment I've got on that.
Right. And then from there,
Yeah.
Sorry. From there,
So,
do you want to finish the answer? Sorry.
Yes, I can do. So from its progression, if we're talking about where this then progressed to,
Yeah.
at the regulation 18B consultation, my understanding is that the LPA met with the promoters of the site to discuss the site-specific constraints in more detail. This is beyond the broad brush assumptions that are in the SLAR, through this process, it was decided that the residential development would only occur in the north, on the north side of the site, and this is once the site-specific constraints were factored in and other policy compliances. And the capacity of approximately 100 dwellings was reached and included in final policy wording.
So if we have a look at the stages of that, if you go to CD 4.5, please, the Reg 19 plan, and we know that we're dealing with the document in October of 21, and the relevant page is 215. So we see the words that you've just told us at the top of that, 100 dwellings at an average of 30 dph. That's the reduction that you're talking about in your previous answer, is it?
Yes.
Right. And then we know that from this point in Reg 19, we get through to the words in paragraph 1 that we've already looked at, and the position stays the same. In that regard then, in terms of the Reg 19 plan and the plan that we now see, how consistent has the council been in its approach to the capacity of the site?
Can you repeat that, sorry?
Yeah, looking at the documents we've just seen, the SLAR, then the SLAR, then the change to the Reg 19 plan, and then into the plan that is before us as an adopted plan today. How consistent when it comes to policy making has the council been on the capacity of this site?
Well, very consistent, so yeah.
Right. Topic 3 then, compliance with the development plan. Let's start with the allocation. So that's back to CD 2.1. Within that you'll find the allocation on page 282. I've already asked you about paragraph 1 and you've explained why you don't consider there to be an approximate development that is approximately 100 dwellings at an approximation of a 30 dwellings per hectare. I want to talk about the conditions though, please. So those are in paragraphs 2 and following. What is your view in respect of how this proposed development complies with the conditions in the allocation?
Okay, I'm just opening up the policy for my reference.
Yeah, so it's CD 2.1, page 282.
Yeah. Okay, so first off, the site exceeds the approximate confines of the policy in terms of the number of units, as we've mentioned, and the density. And this is reiterated again then in the design and layout conditions under number 2, that importance of the approximate number. So what is evident to me is that the development has not been landscape-led. It's been led by a number, as we've kind of gone through on that timeline. And there's been a failure here to deliver any notable internal structural landscaping as set out within condition 5 of that, paragraph 5 of that policy. And in addition, and also on part 15 of that policy, it says that the development proposal shall be designed to take into account the results of a landscape and visual assessment undertaken in accordance with the principles of guidance in place at the time. So there's no evidence of that in this application, but because it's missing that internal structural landscaping, having reviewed the indicative layout and the parameters plan, there's no scope there, in my opinion, to create a significant or suitable area for that internal structural landscape.
So we've got conflict with those 3 parts of the policy. The next policy we need to look at, please, is LPR SP15. So stay in the same document and go to page 206, please, 206.
Yeah.
What is your view, please, in respect of compliance with this policy?
So the key thing that stands out with this policy is that high quality design is required. So, and then there's clear criteria that sets out a need to enhance the local and natural character of an area, noting particular regard should be paid to scale, height, materials detail in mass, bulk, articulation and site coverage, and that's covered within part 2 of that condition.
Do you think there's compliance with that part of the policy?
Say that again, sorry.
Do you think there is compliance with that part of this policy?
Do I think it complies?
Yes.
No, I don't. I appreciate this is an outline application and there's elements within this wording that wouldn't necessarily, we're talking about materials, but on the whole, we're talking about the scale and the bulk and the articulation and the site coverage is the main thing that stands out to me. That's a failure in regards to this scheme.
Right. What about the other parts of this policy? How does the scheme match up against those?
So, under Part 7, there's a need to provide high quality design which responds to, and the relevant part is the landscape value. And in my view, it doesn't respect the topography, and it's not responsive to the location of the site, and it doesn't sensitively incorporate natural features.
So what's your view therefore in respect of compliance with, is that part 7 that you're referring to, or part 6?
So the number and density of dwellings is considered to restrict the ability to be able to sensitively design a scheme that responds to the topography of the site. That's that's my main conclusion.
And then part 7, compliance on that part, please.
Compliance.
Yes. What's your view on compliance with that part of the policy?
I don't think it complies at all.
Okay. Now let's move to policy LPR SP14A. Find that on page 197 of the same document, CD 2.1, page 197. Yes, CD 2.1, page 197. That's policy LPR SP14A. It's titled The Natural Environment.
Yep.
And in your evidence, you've drawn specific attention to this policy and part 1B. Can you explain why you've done that?
So the relevance is that the site is close to the LLV, and it's considered to be in an area of positive landscape character. The policy specifically seeks to protect these positive aspects.
And in your... Well, let's deal with it first. There is an issue about to what extent this applies, given we are not in the open countryside. Help me with that. What is your view? Does this apply, notwithstanding the fact we are within a settlement boundary, or not?
Yes, of course, it does apply. It's within the setting of the LLV. There's not a wall between the two. It's a consideration.
Right. And in respect of this, in your evidence, you talk about this is your paragraph 44. In the final sentence of that, you talk about there being a consequential breach of this policy. Just explain, please, what you mean by that.
So my view is that this would be harm to the setting of the Greensand Ridge by not adhering to the approximate quantum of units and the density as set by the site allocation.
And then the next policy to look at is LPR SS1. So stay in CD 2.1, go to page 33, please.
Yep.
And in this policy, you've highlighted paragraph 14, which you find on the bottom of page 35. It's under the subheading Other Locations. And it says that the green and blue network of multifunctional open spaces, rivers and watercourses, the Kent Downs National Landscape and its setting, the setting of the High Weald National Landscape and landscapes of local value will be conserved and enhanced. Again, there seems to be an issue about whether this is relevant given we are dealing with a site in the settlement boundary, not in the open countryside. What's your view on that, please? Is it relevant notwithstanding that or not?
Sorry, could you just rephrase that ever so slightly?
Yeah, absolutely. There's an issue taken by Mr. Ross as to whether part 14 of this policy is relevant because we're dealing with a site that is inside the settlement boundary. What's your view on that issue? Is it relevant or not in your view?
Sorry, I really can't hear you very well.
That's okay, I'll say the question again. There is an issue taken by Mr. Ross as to whether part 14 of this policy is relevant because we are dealing with a site that is in a settlement boundary, within the settlement boundary.
The policy is relevant because we are in the setting of the LLV.
And then in your proof of evidence, you talk about, going back to, we were looking at that a moment ago, moving on from paragraph 44 to 45, you talk about a consequential breach of the policy. Can you explain what you mean by that, please?
Sorry, I just need to have a moment.
Okay, that's fine. Take your time.
Right. Sorry. Can we restart that again?
Yeah,
Sorry.
that's fine. We were looking at policy LPRSS1 and paragraph 14 of that policy, and you've explained in your view that's relevant to this development.
Yeah.
And in your proof of evidence, you deal with this at your paragraph 45.
Yeah.
And you describe there as being a consequential breach of the policy.
Yeah. Okay.
Can you just explain why you reached that view, please?
So yeah, sorry about that. I just wanted to kind of go back to the relevance, if that's possible.
Okay.
So the spatial objectives highlight a need to protect the key characteristics of the site, of such a site, and it indicates that development will conserve and enhance landscapes of local value. Part 14 specifically talks about the need and importance of protect the LLV. And then you asked me about the consequential impact, and for me that's the harm to the Greensand Ridge.
Thank you. So, in light of that, and in light of the policies and the development plan as a whole, what is your view on the question of whether there is compliance with the development plan taken as a whole, please?
When taken as a whole, we are looking at that the strategic function of the policies SS1, and which has that running theme of protecting landscape and LLVs. Then you have a number of topical conditions such as the design policy and the policies on protecting the natural environment, and they also reiterate that point. And then it comes through again within the strategic site allocation. So you have this consistent message all the way through the plan, and for me that shows that on the whole this is not compliant.
Right. Now let's look, please, at some of the next topics, the plan and balance. So with that question in mind, let's go and look, please, at some of the other material considerations which are relied upon by the appellant.
Yeah.
The first of these is in terms of economic benefits and what's described as capital investment to the local area. Your view, please, on that factor in the plan and balance. How much weight do you afford to it?
So in terms of the economic benefits, short-term employment benefits have been identified through the creation of some direct creation of construction jobs, and then there'd be some additional household expenditure in the local area. I've given this limited weight overall.
Yeah. And if we focus in just on the additional 12 dwellings, have you seen any evidence that differentiates the economic benefits of 100 versus 112?
No, I would no. There'd be very limited benefits from an additional 12, if any.
Right. Moving on to the next series of benefits, these come under the subheading social.
Yeah.
Ask you to start, please, with the provision of housing.
Yeah.
Your view on that benefit, please.
So the provision of housing on social benefits has some. Sorry, I just need to refer back to my statement of case. Bear with me.
You deal with these on your paragraph, your page
Sorry,
19 and 20 in your proof of evidence, if that's what you're looking for.
Yeah. So page 18 and 20. So the creation of, so I mentioned that there'd be up to 112 new homes, including 45 new affordable homes. And I give that, sorry, I just need to go to my weighting. Sorry, please bear with me. So in terms of the market housing, I give moderate weight, and in regards to the affordable housing, again, I would give it moderate weight. However, when it comes to the additional 12 dwellings, if they were to be considered in isolation, I'd give that no more than limited weight.
Right. And why did you say that?
The reason why is because 12 is not a large number, and we have a strong over delivery to deliver the expectations of the plan.
Right. The other factor to deal with under the subheading social benefits is that of open space. What's your view on the provision of open space, please?
So, open space provision on Site A, there's limited, so there's open space provision on Site A, and then there's limited provision on the main development site for peripheral, in the way of peripheral green space corridors, and then a structure of relatively narrow internal green space corridors, and then there's two small greens, one at the entrance or the arrival point of the development, and then in the south of that site, in the northern site, and then one central near the southern central part of the site, which is marked on the parameter plan. The green by the entrance is likely to be subdivided by roads, by the road, as well as a location for vegetation, which would include screening. So, because of the way that the screening would need to be reduced for the visibility of that entrance, I think the development would this would have limited weight, this provision, in my view, because less development would result in more open space, essentially.
Okay, so that's the factors under the social head, and under the environmental benefits, BNG, please. How do you tackle that as a benefit?
Yeah. So with BNG, I consulted with KCC Ecology. They have, the stated BNG on this site would be 27.54 as proposed. However, KCC Ecology have responded to say that they have doubts about the delivery of that. Unfortunately, we're not at a position where we know have any response on that, but so the minimum I could secure within this development would be 20%, and that is a policy compliant requirement. So I'd give that limited weight. But in this circumstance, an additional 12 units reduces the ability to deliver biodiversity net gain, and the gains identified are not considered by, as I've mentioned, by KCC to be achievable, but the scheme would be policy compliant.
Right. So that is the benefit side. The harm side, in terms of the conflicts that you've identified with the allocation and policy LPR SP15, what weight do you afford to those?
So that's
so moving from the benefit side of the balance to the harm side of the balance, you've got your conflicts that you've identified with the allocation, LPR SA248, and policy LPR SP15. What weight do you give to those conflicts?
I'm sorry, I've lost my sort of train of thought. Can you just say that again?
Yes, that's fine. So we were dealing with your proof. We've just moved into your section 8, which starts on page 21. And we've dealt with the benefits. I want to look at the other side of the plan imbalance, please. That is the conflict that you've told the inquiry about in respect of the development plan policies, LPR SA 248 and LPR SP 15. What weight do you afford to those, please? What weight do you afford to that conflict?
So, in terms of the conflict, I give these conflicts significant weight.
And why do you do that?
And that is given the strategic importance and the analysis I set out. So, and that's because I disagree with the identification of design as a benefit, really. And I think this is a harm. So and it's evidenced by the way of excessive density and the quantum of development.
So what conclusion, therefore, do you reach on the plan and balance as a whole?
As a whole, as I've mentioned before, when looking at the policies beyond the site allocation, it's clear that there's a running theme throughout the plan about protecting landscape character, and in particular, LLVs are one feature that is of great importance. Consequently, design is expected to be of a high quality. When you consider the site allocation, it's clear that the development fails overall to deliver a high quality scheme. Yeah.
So in terms of the plan and balance, what is the outcome that you reach?
So the outcome that I reach in my recommendation, or
in the overall plan and balance,
that the scheme is unacceptable.
Right. Thank you. So they're all my questions in chief.
Say that again. Sorry. That's it. Okay. Sorry.
Thank you. I presume you have some questions, Mr. Tucker. But I wondered, Mr. Scott, I presume this is you wearing another hat again. Would you mind turning that light off again, please, if that's okay? I think the switch was just outside of the room, if that was right. No, not that one. No. There we go, that one. Thank you. Much appreciated. Thank you.
Thank you, sir. Good morning, Mr. Scott. Mr. Scott, these microphones are echoey. Sometimes during the course of cross-examination, we tend to speak quickly, both you and I have no doubt. If at any stage you need me to repeat a question because of the inaudibility, please say so. Mr. Scott, can I just start off with one question which really goes nowhere, but I am genuinely interested. Are you here as an employee of Maidstone Borough Council, or are you here as a consultant?
I'm here as an employee.
As an employee,
yeah.
Thank you. And in relation to your role as a planner, planners are great because they can be jacks of all trades and they can rely upon the evidence of others informing their conclusions. Do you rely upon the evidence of Mr. Kirkpatrick in relation to the matters which fall within his area of expertise?
Yes, I do.
And you've now read his evidence and seen his evidence and heard him explain his evidence yesterday. Do you disagree with any part of his evidence?
Not as written, no.
Good, thank you. That helps because I don't need to ask you any questions about the areas that fall within his area of expertise. Thank you. Next, the reasons for refusal. And I say reasons because they're putative reasons on core document, forgive me, core document 9.1. Tell me when you're there. Interesting that it's in a formal way, so you've got a decision notice, even though it's a putative decision. Formally, we are only arguing, or you are only inviting, subject to the 106, the inspector to dismiss the appeal on ground on the first reason for refusal, aren't you?
Just say that again, sorry.
Formally,
Yeah.
subject to the signing and completion of the section 106, which hasn't happened yet because we've not discussed it, you are only inviting dismissal of the appeal on the basis of the first putative reason for refusal, aren't you?
Yes.
Thank you. And the first putative reasons for refusal, so the formal position of the council only alleges breaches of two policies in the development plan. That's SP15 and SA284, doesn't it?
That's what it says here.
And if you look at your paragraph 67, that's what you say in your proof. Agreed?
Yes, that's what I say.
So, simple question. Is your evidence consistent with, or your professional view consistent with, or inconsistent with the formal position of Maidstone Borough Council at this inquiry that there is conflict with only two policies of the development plan?
I would bring in that the plan has to be read as a whole, so there are other policies that are of relevance to this consideration.
We agree, but that's not an answer to my question. We agree there are other policies which are relevant. It's in the statement of common ground that there are other policies that are relevant. I wasn't asking you about policies which are relevant. I was asking you about breaches of policy.
Yeah,
the formal position of the council, repeating
Yes.
its statement of case, repeating your paragraph 67,
Yes.
set out in the putative reason for refusal, is there's a breach of two policies. Is your professional view before the inspector that there is a breach of two policies or more than two policies? In other words, are you being consistent with your own council's formal position?
I'm going to stick with the two, I think. So in terms of those two policies, that's what I've stated, and that's the there's other policies that come into consideration.
Yeah. Well, let's look very quickly at those, given that you're sticking with the two, which is helpful. Can we have a look at LPRSS1, which is in the local plan, which is core document?
No, I'm sorry. I have to go back. I don't. Sorry, it's not just about the two policies. On the intended decision notice, there were two policies stated. There are other policies that need to come into this in the round.
Yeah, I try to be specific, Mr. Scott, and it's obviously a precious situation, so I'm not in any way being critical of you. I don't mind what your answer is. I don't mind your answer that the decision notice is wrong, that your line manager's got it wrong in signing off the decision notice, and that there are other breaches of policies, or that you say that your line manager's got it right when he signed off this decision notice. I don't mind whichever way it is, because I can then distinguish between the position of the council and your professional opinion in closing, or I can say your position is consistent. But you're here to help me, as to help the inspector, not help me, but help the inspector, giving your untrammelled professional opinion as to what your view is. So that's all I'm asking about. Is it your view that the decision notice is right in citing only two policies, or is your view inconsistent with the decision notice?
On reflection, my view would be that there's other policies to be considered on that decision.
Yeah, specific question demands a specific answer.
There should be other policies stated.
So your view is inconsistent is the answer to my question, is that right?
Well, It would be inconsistent with that, yes.
Yeah. So the decision notice says 2 policies are breached. You say that there are 4 policies which are breached. Is that right?
Correct.
Right. Let's have a look at that. Firstly, then, the one I was taking you to, policy LPRSS1, which is the spatial strategy.
Yes.
Point that you've just made to me, we have to read the spatial strategy together with the plan read as a whole as to how the council uses the spatial strategy to inform other policies. Agreed?
Mhm.
This spatial strategy has been used to balance a number of different factors, including the need for housing and also the need to conserve the natural environment. Agreed?
Agreed.
When we read LPRSS1 in a development plan, we read it in the context that this site is an allocated site where the principle of development for residential development is accepted. Agreed?
Yeah.
So when we look at LPRSS1, let us assume that what we are proposing is what you think to be an allocation-friendly proposal. Let's assume that we do that. Let's assume that's the conclusion that's reached. Is it your case that an allocation in an recently adopted development plan would be in breach of the council's spatial strategy? Or should it be read to be consistent with it?
The SS1 is clear about preserving landscapes of local value and the Greensand Ridge LLV. That doesn't take away from the fact that this is a strategic site. It still needs to be considered.
Yeah, I'm going to ask for precision again, and if you need me to rephrase my question, please do so. Let us assume you have on your desk as a development control officer a proposal which accords with the allocation within Yalding. So we're ticking the box in relation to that. But it doesn't conserve the Greensands landscape and the LLV because it has an effect on it. And you'll recall the witness yesterday that said the effect is a greater effect, not
Yes.
no effect. Is it your position as a sensible planner that the inspector should read SS1 that if there is any effect at all on the LLV, a proposal would breach SS1, even one that complies with the allocation? Because that's just daft, isn't it, Mr. Scott?
I wouldn't agree, no. I think that it still is of relevance, and as I've set out, the approximate, what I consider to be approximate, could be above or below that number, and it needs to be demonstrated within the site allocation.
I didn't ask you a word about what you just answered. Mr. Scott, I don't in any way wish to have to repeat points.
Right.
I'm going to ask you this for one last time. If you don't want to rephrase it and think of a different way of asking it, so be it. But if you choose not to answer it, I'll make submissions about your choice not to answer it in closing. Okay? Third time. Is it your position that if one came forward with a proposal which met the allocation but nonetheless had an effect on the LLV, mindful of exactly what was being said by the witness yesterday, that would accord with or not accord with SS1?
It's a balance, but I think what you're asking me is, if a policy compliance scheme came in, would it have an impact on the LLV? And the answer is yes.
That wasn't what I asked you.
So
That wasn't what I asked you, but I'm not asking for a fourth time. You
Okay.
choose not to answer, it's a matter for you, Mr. Scott. Let me ask you in relation to the other policy that you cite. So let us have a look, if we may, at policy SP15, if you would please. SP15. My machine has stopped finding, I'm afraid. Yeah, sorry, it's page 204. So we've got a general policy on the principles of good design, yeah?
yes.
This is a policy which applies to both outline applications and reserved matters, and you have to use that prism, don't you, when considering whether there's compliance or non-compliance with relevant parts of the policy. Agreed?
Yeah.
Thank you. Just to be clear, in terms of the development for which the application is sought, that seeks outline permission subject to a parameters plan, with the only thing for detailed determination being the access into the site, yes?
Yeah.
What is your assumption when assessing policy SP15 about whether the council will do its job properly on a reserved matters application? Will it or won't it?
Well, the council will do its job properly.
Good. Thank you. So if an outline consent is granted, then this will be a policy which will be of particular relevance in relation to matters of scale, bulk, appearance, design, layout, etc. at reserved matters, won't it?
There are elements within the outline.
Please answer my question.
Right.
Because it's a really simple one. Because the question, is a design policy relevant at reserved matters application?
Yes, it is.
Plainly demands of a simple, straightforward answer.
Yes, it is.
And if we fence, we're going to spend a lot of time today.
Mm-hmm.
Is it a policy relevant to reserved matters?
Yes, of course it is, yeah.
Thank you. You wanted to qualify in some way. You wanted to qualify your answer, and I won't stop you qualifying your answer.
Okay, I was just going to say, if I may, at outline, this is still a consideration as a policy.
Sure. But the question on an outline application would be whether or not, subject to the details which have been applied for, a scheme is capable of meeting the principles of good design. Agreed?
Correct.
And the resolved position of the authority, in contrast with your position, is that this is a policy which isn't breached at outline stage. So can you explain to me, mindful that this is an outline stage, why it is that, in principle, 112 units would not be able to meet the terms of this policy?
Okay. So, in my view, I've been provided with a parameter plan. I've also been provided with an indicative layout, which, to my expectations when viewing an application, this is showing me the best optimal layout for the scheme going forward.
Really? That's what you think an indicative layout is? Well,
it's showing me, it's demonstrating that the site can achieve the aims of the policy overall, of the strategic policy and of the policies of the local plan. That's what it's got to do. This is a strategic site.
No, I'm so sorry. That's two different things. You told me this is the best layout, and this is showing me it can achieve the policy.
Right. So it's showing me.
Hold on. It's not a conversation. This is question and answer.
Mm-hmm.
Which is it? Have you read an indicative layout which shows illustratively how, in principle, we think the site could accommodate this form of development? Illustratively indicative, or have you read this as essentially my client's best shot at the best way to develop the site?
Okay, I rein back on that. It's demonstrating that the site can hit the aims of the strategic policy, of the site allocation, sorry.
Yeah. It doesn't determine layout, does it? At this stage, if permission's granted?
No, but layout is a consideration because we're seeing how the site might function.
Might, but it's subject to the authority seeing the exact proposed layout and forming a view. Agreed?
We need to know that there's flexibility within a design, though, to be able to have that ability to make those changes at reserved matters stage if necessary.
Doesn't determine plot size, does it?
No.
Doesn't determine bulk or scale, does it?
No.
Doesn't determine landscaping, does it?
Going back, the parameters plan does, to some extent, it sets height limits. So there are things we can consider there that we can count on as being a fixed feature coming forward.
Sets maximum height limits, but I didn't ask you about height limits, I asked you about landscaping. This doesn't determine landscaping, does it?
The parameters plan
This, the
The
illustrative master plan
yeah.
we're still looking
So
at.
that doesn't.
Thank you. So it doesn't determine scale, layout, appearance, design, landscaping. It shows one possible way of bringing the site forward.
Yeah, I appreciate that. Yes.
Yeah. And even the internal landscaping that's shown on this plan depends upon exactly what the internal configuration of the site is. And the inspector should view this plan mindful that if there are shortcomings with it, don't accept that there are, but if the inspector thinks there are shortcomings with it, he shouldn't stop there, should he? Because what he should say when looking at the illustrative master plan is, I'm not determining this because the authority gets another go at this to identify, based upon an LVIA, I've no doubt, mindful of condition 5, to determine how this could be improved upon if you think there are shortcomings. That's the way to approach an in-principle illustrative master plan, isn't it?
Yeah, but there's one thing to make clear, and that is that the indicative layout has to abide by what's in the parameters plan. So we can't all of a sudden change an urban form to a amenity or landscaping, or that making meaningful divisions for landscaping within a development, as the inspector laid out in his final letter, as an area of importance.
Good. That's exactly where I wanted to take you next. Let's go to the parameters plan, which is for determination, we say.
Yes.
Site B, that which lies south of Kenward Road, together with the corner with the blue star on it, you don't have any issue with, do you?
No.
The dark green area is where the BNG is, isn't it?
Yeah, can you just allow me to bring that up? Sorry, I haven't got
Yeah,
a
by all means.
core document reference.
I'm so sorry. I should have given you that. .518, thank you. We did have lots of spares on the back, but they seem to have gone walkabout overnight for some reason. So the dark green at the very south of site B is where the BNG is, isn't it?
I can't confirm that off the top of my head, no.
Okay, don't worry, I'll come back to that at a later point. The site coverage, so the salmon pink area of where the net developable area is,
Yes.
we know, because we discussed that yesterday, is 167, rounding up, 166.6 recurring, is 167 square metres larger than a site coming forward at 100 dwellings at 30 dwellings per hectare. You recall that maths yesterday?
Yeah.
Right. So we know that site coverage isn't an issue. You rely upon what Mr. Kirkpatrick said. It's all about density. You recall that?
Mm-hmm.
Is that your position too?
I would say that it's about density and the quantum of development.
Yeah. Well, density is a function of the quantum of development. It's the
Of
mass
course.
and the geographical area.
Mm-hmm.
And we've dealt with the geographical area. Site coverage of itself is broadly the same as a 30 dwellings per hectare 100 scheme. It's less than the size of this room difference. In terms of the parameters which are fixed, let's have a look what they are. The landscape and open space around site A, we now know from Mr. Kirkpatrick that there should be landscaping around the salmon pink area, but there should be a bit less on the east side, a bit more on the west side, and that the entrance area should have a bit more. Okay, I'm going to take that that's evidence that's already been given. But we've got this dotted line going through the middle of the site, which says indicative arrangement of planting corridor. Does that determine the width of that planting corridor, if this appeal is granted?
It gives an idea, but it's not very clear.
What's the answer to my question?
So, please ask your question again.
Okay. Does it determine the width of the planting corridor?
Yes, it would.
The indicative alignment would determine the width. Have you approached that? Have you assumed that? Is that part of your assessment, Mr. Scott? An indicative alignment determines width.
Well, this is what we're talking about, is a parameter plan. I would expect there to be some trueness to what is coming forward, and if I can't rely on the width of this, then what can I rely on? I appreciate this could move slightly, but as the appellant has indicated in their planning statement, these are fixed parameters.
So you've approached this believing that there will be essentially a long rectilinear line going through the site, the centre of the site. That's the only place where there'll be planting. Is that your analysis, Mr. Scott?
I've been told that this is a fixed parameters plan.
No. Could you answer my question, please? Is it your analysis that you've assumed that the planting outside of plots will only take place within these green lines? Is that what you've seriously assumed?
I expect that this is the framework for where the land uses are going, and this is the indication that I have of the internal landscaping. I appreciate there may be differences in the urban layout on the gardens and things like that come forward, but as far as the structural internal landscaping is concerned, this is what I have to rely on.
Yeah, that's again not answering my question. Forgive me, what do you understand by the term indicative?
Something that might come forward in that form.
Something that might come forward in that form. Would that mean that it might not come forward in that form? Is that what indicative is telling somebody?
Well, yes, but I think it's going to have to be close to what's here, really, because that's all I've got demonstrated.
So if it might not come forward in that form, the parameter plan isn't fixing the width, is it? Which is where we started 5 minutes ago.
But I have an area of landscaping which, okay, it could shift slightly, but that's all I've got.
An answer which starts with but is not answering my question, Mr. Scott. I'll ask once more. If you choose not to answer it, I'll add this to the list of not answered questions. Something which might not come forward in that form does not fix the width, or indeed the alignment, does it?
It's strictly speaking, no, but it's on the planning, it's on the drawings.
So it doesn't fix, thank you. So that's a matter for the authority to consider in terms of the detail at reserve matter stage, isn't it? For example, planting of trees both sides of the road, planting of trees within internal access roads, small pocket parks. Agreed?
It could be, but there's such a vagueness about what this could be. It's not fixing. This is about the uses, and this, from what I see here, is it could be an avenue of some trees. It's not hitting what the inspector has asked for in his final report, which is the meaningful internal structural landscaping.
Was the inspector talking about an outline application where factors such as this aren't being fixed at that stage?
No.
Was he talking about the detailed consent which will ultimately come forward to bring forward development?
Yes.
So how is that a relevant answer to the point?
The planning permission, if there is one, is to this needs to demonstrate that could happen. So what have I got here to tell me that there's going to be a meaningful internal structural landscape?
So when an application lands on the door of any authority, and this application landed on the door of the authority in November 2023 after 2 years of pre-apps, during the course of a local plan examination at which development here was supported by the authority, it would have been open to the authority to unreserve any of the details which my client sought to be reserved. Internal layout, design, appearance, layout, landscape. You could have unreserved any of those elements. Did you?
No.
So based upon what the council has lawfully done, have said we can determine this application and determine the principle of these matters, your point goes nowhere, does it? In terms of saying we don't have more information, because you and my clients are complicit in the information that's before the inspector. Agreed?
I don't agree, no. I think that the land uses here, we've got the salmon pink part, as you describe it, is the residential area. I don't see a way that we can bring in new land uses, as landscape is a separate land use.
What?
So we've got...
Sorry, just hold on. You think landscaping is a separate use on a residential application?
It's a separate... You see how we have in the key, land use residential. There's a clear distinction between land use residential and land use landscape and open space. That's all I'm saying.
No, I'm really sorry, Mr. Scott. And this is grandmother's and egg sucking. That's setting out what's called a land budget. This is an outline application for residential development of the whole site. This is telling you what the land budget is, i.e. the areas of land which are being used for different things within the residential application. They're not different land uses in terms of there being material differences between them.
No, I understand that.
Right, good.
Yes.
Thank you.
It's more the distinction between, it's a key showing where different uses will be, different elements of the scheme will be appearing.
Okay, let me pick up a couple of other points from your examination chief. Let's move away from this little cul-de-sac. Next. We were taken on a trip down memory lane to Ashmar, and we were taken to the Reg 19 plan. This is a question to help me see if I need to make submissions about what the courts have said is forensic archaeology. Do you say there is any ambiguity in terms of the policy which allocates this site?
So we're talking at Reg 19?
No, I'm talking about the policy that we are determining the application under.
Right.
So I'm talking about LPRSA 248.
Okay, and you're asking if there's any ambiguity about it?
Yeah, are you saying this is a policy which is so ambiguous that we need to go into what the courts have said is forensic archaeology to see what sits behind it?
Sorry, slow down, please.
Of course. Are you saying that the policy LPRSA 248 is ambiguous so that we need to look into the background of that policy to understand what the policy means?
I don't think it's ambiguous.
No, nor do we. Good, thank you, that's helpful. Next, density. We have to read the policies and the plan as a whole, don't we?
Yes.
Thank you. When we do so, we can look at the policies in isolation and the parts of policies in isolation, but they need to be read in context to understand those policies. Agreed?
Mm-hmm.
Good. Let's have a look at the allocation, if we may. Jeez. Just wait till the bell stops ringing.
We're going to the allocation, are we?
Yeah, 282. We're dealing with the vexed issue of approximation here. Let us assume that the only thing that we can look at is the allocation policy, first of all, to understand what is meant by the words in the policy. And the term approximately appears, I think, 4 times in this policy, qualifying 100 and qualifying 30. And
yes.
In ordinary parlance, approximately means there or thereabouts. And it can be plus or minus if you're dealing with a number. Agreed?
Yeah, I would say close to, but yes.
Close to, there or thereabouts, whatever it might be.
Yeah.
However you want to look at it. And that can be plus or minus.
Of course.
Yeah. If that's all you're looking at. So if all I looked at was this policy, then the interpretation of this would be, it could be either way, plus or minus.
Correct.
In terms of what it means in any given context as to whether a given application should be treated as being approximately 100 or approximately 30 dwellings per hectare, that's a matter of planning judgment for the decision maker, isn't it?
Mm-hmm. Yeah.
So ultimately, the inspector will form a view as to what that means. There is nothing within this document which defines approximately, is there?
No.
So there is nothing which tells us it's plus or minus 5%, 10%, 12%. We know there's a difference of judgment between yourself and Mr. Ross, don't we? He thinks 12% is probably caught by approximately, you think it isn't.
Yeah. I think we have to look at the context to the site. It's a sensitive site. It's in the setting of the LLD. And I think, you know, moving from either side of the approximate figure, the further away you move from that, the more potential harm you have on those elements.
Well, it depends which direction you go.
Well, there's the whole point about having to optimize the site, and there's the whole point about having to protect the characteristics of the area.
Hence the reason it's a balance, which you've told me. It's a matter of judgment.
Yes.
But that wasn't my question.
No.
I asked you about the differences between you and Mr. Ross, which I think is, again, a fairly straightforward question.
Yes.
Mr. Ross thinks 33.4 and 112 is caught by approximately, based upon his judgment of all the factors you've identified. You think it isn't.
That's correct.
In fact, you go further in your evidence and you say plus or minus 10% wouldn't be approximate. It's got to be something less than that.
I would agree, yes.
Yeah. And just to be clear, you don't give us a figure as to what it might be as to plus or minus. Hence
No.
the reason why I put plus or minus 5% to the previous witness. Is it of that sort of order that you have in terms of your judgment?
Yes.
So let's think about the consequence of that. Because you tell us if you go beyond the approximately 100, then that means there's a conflict with the policy. So your judgment, in principle, subject to other things, if you go below 95, there's a conflict to the policy. If you go over 105, there's a conflict to the policy. That's broadly speaking your judgment, yeah?
Potentially, what I would need to see is a demonstration that the site can function well within a given density and at, you know, within the approximate of what I consider approximate.
Yeah, no, but I just want to be clear because the inspector will need to know the council's position in terms of saying, well, hold on a second, if this appeal is dismissed, what will the site come forward for? And it's not coming forward for something that's significantly less than 100, is it? If the allocation terms are met, on your judgment.
I wouldn't expect it to come forward without the demonstration that the site can function well in terms of its, you know, indicative layout.
So, let's have a look, please, at, let me see if I can start this in a different way. Let's have a look, please, at page 134, where you were taken by my learned friend and into the designated neighbourhood areas, which is LPR SP10. Why on earth every one of your policy has the prefix of LPR is beyond me, but there we are. So SP10, your housing delivery policy. You were taken to paragraph 7 of this policy under designated neighbourhood areas.
Yeah.
Let's see what that means. Paragraph 7.3, designated areas. Currently 16 neighbourhood areas in the borough. The housing requirement for the designated neighbourhood areas has been considered in the plan. In considering this, consideration of the documents, the plan includes a number of allocations within the designated areas. ... The number allocated through plan policies is not a maximum number, nor is it finite. You see that?
Yeah.
Goes on, 7.4. The table below sets out the indicative minimum housing requirements for each of the 16 designated neighbourhood areas. So indicative minimum housing requirements. Again, indicative doesn't fix it, does it? But the use of the term minimum is there, yeah?
Mm-hmm.
So let's have a flick down. Yalding, the indicative minimum number of requirements expected as a consequence of this policy is 100, isn't it? Indicative minimum.
Yeah, across the neighbourhood plan area. Yeah.
Which could include both the allocation and any windfalls, couldn't it?
Well, this would not sit in, this doesn't consider the site allocation. This is a neighbourhood plan that could come forward potentially. We are not talking about a neighbourhood plan that we have. This is an indicative guide.
Yeah, of what the neighbourhood plan should be producing to meet the minimum requirements for that neighbourhood, and it's telling the neighbourhood plan body, if one comes forward, this is what you've got to do as a minimum to secure that. And the minimum requirement for the neighbourhood area would be 100. Indicative minimum requirement for this. Agreed?
Yes.
Don't get me wrong, if you're saying it excludes the allocation, that helps my case enormously.
Yeah.
It includes
no, I'm
the
not saying
allocation,
that.
doesn't it?
I'm saying that's, yeah, it says it's a minimum.
Yeah, so the indicative minimum housing requirement for this neighbourhood includes the allocation of approximately 100. Agreed?
It includes 100, yes.
Right. Can we turn to page 296 next, please?
Of the plan.
Of the plan. Policy you weren't taken to in evidence in chief. Paragraph 921. So HOU 5, paragraph 921 tells us that the development strategy is based upon meeting future housing requirements, and that's looking towards things like the trajectory. And then it says the setting of minimum densities for residential developments will help the council to achieve this and make best use of land, whilst also being in line with national planning policy, paragraph 125. That's the one that says you should refuse if you're not making making efficient use of land. So
Right.
setting of minimum densities will help the plan accord with national policy. You see that? Do you see that, Mr. Scott?
Yeah.
LPR HOU 5, density of residential development. All new housing will be developed to density consistent with achieving good design, doesn't compromise distinctive character. Development proposals that fail to make efficient use of land for housing, having regards to the character and location of the area, will be refused permission. Words which resonate with paragraph 125 MPPF. That sentence is relevant for any application for housing anywhere in this district, isn't it? If you don't make efficient use of land for housing, you'll get refused permission.
Yeah.
That's something the inspector should bear in mind when looking at this site, isn't it?
So there needs to be, this is a site allocation.
Could you give me a direct answer, please, to my question?
We would expect developments to optimise sites.
I'm so sorry, Mr. Scott, because I don't want to go off on a little sidestep.
Yep.
You may play rugby league, I don't know, because you're excellent at sidestepping. My question was a specific one. Is that sentence relevant to this proposal? Development proposals that fail to make efficient use of land for housing, having regards to the character and location of the area, will be refused permission.
Well, yes.
Good. So there is an obligation in policy for any application for housing to come forward and make efficient use of land. Otherwise, you'd expect to be refused. Agreed?
Efficient use of land, yes.
Thank you. Subject to these overriding considerations, note the words overriding there, the following minimum densities are expected in the following locations. You see that? Yeah. Last sentence of the preamble to the policy. Following minimum densities are expected in the following locations.
Yeah.
Paragraph 5. At sites within or adjacent to ... larger ... villages, new residential development will be expected to achieve a net density of 30 dwellings per hectare where that is compatible with the individual settings of the site. There is a specific development management obligation to meet a minimum density of 30 dwellings per hectare subject to the particular characteristics of a site in this development plan, isn't there?
That's what it says. It says a minimum of 30 dwellings per hectare, yes. So, yeah.
And that larger villages would include Yalding, wouldn't it?
It would, and but that doesn't exclude the consideration of the other themes of the policy, which are talking about things like LLVs and positive landscape value.
But Mr. Ross makes a fair point, doesn't he? that this plan has an expectation that within the larger village area of Yalding, there is a policy expectation that a minimum density would be 30 dwellings per hectare, and that's a factor to bear in mind when looking at what approximately 30 dwellings per hectare means in the site-specific allocation, doesn't it? That's a relevant factor.
Well, the site-specific allocation is set up for that particular site, so I would refer to the site-specific allocation.
And bless you, you told me that we have to read the site-specific allocation in the context of the plan as a whole, and you have to read it not in isolation but in the context of other policies.
That's right.
So reading it in context, when I look at 30 dwellings per hectare as an approximation for the allocation, I also have to bear in mind the policy requirement that if I don't make efficient use of land, I should be refused, and that for Yalding, there's an expectation that you will achieve a minimum density of 30 dwellings per hectare. Those are both factors that the decision maker should bear in mind.
I would agree with you if that wasn't the case, that it's been stated specifically in a site allocation.
Where does it exclude the bits that...
It doesn't say that, no.
No. Where does policy HOU 5 get an exclusion clause in the allocation of this or any of the other allocations?
Well, the site itself has been examined specifically in regards to the density it sets out in the site allocation.
Big point next, therefore. Big point. Are you inviting the inspector to trot down a little route which might end up in the High Court if you did, but are you inviting the inspector to disregard the policy test in HOU 5 when looking at this particular appeal?
No, I think it's of course a consideration.
Good. So he needs to judge the proposal against HOU 5 as well as the allocation. Agreed?
Yeah.
Good. And when he does so, he will see that the direction of travel of this plan is to achieve the expectation of minimum densities. Agreed?
I wouldn't agree because the site allocation specifically sets it, and there are other considerations to take into account in the plan, not just this one density policy.
Yeah, I'm not asking about whether you exclude everything else. I'm not saying that. Of course there are other points. And the inspector may say, yes, all right, there's an imperative here to achieve a minimum of 30, but there's a good reason not to here. I understand that. Good.
Yes.
I'll happily move on, sir. Thank you. So that's probably a convenient moment to take the mid-morning break, if I may. I don't have much more. Thank you, sir. Thank you, Mr. Scott.
Thank you.
Thank you. That's 11:30, so we can now resume the inquiry. Mr. Tucker, you had a few more questions.
Yeah, about another 15 minutes.
Thank you.
So we'll hopefully get Mr. Williams in chief before lunch. I'm a great fan of the 1980s group, the Smiths. So I'm very keen upon the question, what difference does it make? And that's not winning a bet to get that in. That's actually asking you the question, what difference it makes. Can you turn to paragraph 14 of your evidence, please? This tells us about the fact that on the 2nd of August 2016, the council refused consent for a scheme of bungalows, starter homes and apartments, etc. Tells us why it refused that consent, and you tell us there's a dispute between yourself and Mr. Ross whether it's relevant. Let's ask ourselves what difference it makes. In the event that the inspector thinks that the appeal should be dismissed without regard to this, it would make no difference at all to the outcome, would it? The knowledge that the council has once refused an application on this site for 60 units.
So I think it's relevant to look at the context of that application.
But by all means, but can you answer my question first, Mr. Scott? If the inspector is going to dismiss the appeal anyway, irrespective of this point, it doesn't make a difference to the outcome, does it? You're not saying there's something in here which makes the scheme better, are you?
No.
Right. If the inspector considers, notwithstanding all of the points that you've said, that the appeal should be allowed and that permission should be granted, what is it about this decision which you say should tip the balance against it? Or are you saying that it makes any difference?
The point is that it does make a difference in that in terms of how the impact on character was assessed, and the considerations taken into account. I appreciate that at the time of that application, it was in the open countryside, so it's a different. There is a different premise there, but there is still character considerations which I draw to the inspector's attention.
Are they the same points for a different scheme, or are there any additional points that you're drawing to the inspector's attention that might make a difference?
No, not specifically.
No, there are no additional points, thank you. And just to get it right, you've already told me that at the time, in policy terms, that was open countryside, but now it's not open countryside, in policy terms.
That's correct.
Which is why, presumably, paragraph 180 doesn't find its way into the reasons for refusal.
Right, yeah.
You do say it concerned the same land. That's actually not right, is it? It concerned part of site A and none of site B.
That would be an accurate, that would be accurate.
Thank you. Good. Thank you, that's helpful. That's a neat segue into the issue of benefits. The delivery of Site B as a large area of public open space conveniently located to the rest of the settlement is a benefit of note, isn't it, in this case?
A benefit to who?
Of note.
Of note. It's a benefit, yeah.
Mm-hmm. A delivery of 4 hectares worth of open space subject to the ecological area, is that significant, not significant? How would you characterise it?
I'd have to revert back to my proof, but I think I'll need to go back to it. Bear with me. I think the main thing to say on this is I recognise there's a benefit from open space coming forward, if that's enough.
Well, with respect, it's not enough. Are you accepting that there is a significant benefit arising from that?
A significant benefit? I'm not recognising that. No, not a significant benefit.
Well, that's odd. Can you turn to core document 11.1, please? which should be the statement of common ground, which I thought was agreed. When you get to it, it's paragraph 6.64. And this is section 6 is the areas of agreement.
Yeah, 6.64 you're saying.
Yeah, which says it's agreed that 4.3 hectares of new public open space south of Kenward Road exceeds the general requirements of policy, makes an important contribution to addressing forecast deficit and open space provision in Yalding. It is agreed it's a social environmental benefit, which significant weight should be given.
Okay, agreed.
Hold on, because that's indicative of an approach. So you've now just told me, having had this drawn to your attention, that you're giving it significant weight. Why wouldn't you accept that before I drew this to your attention?
I had written this some time ago, and I couldn't remember the exact weighting that I'd given to this
No,
element. This is not an area of dispute. We are talking about areas of dispute, aren't we?
We are, but this is a professional judgment point, Mr. Scott, because I've just spent the last 5 minutes asking about, can you give significant weight to the delivery of 4.3 hectares of open space? And I asked you whether you could do that, and you've told me, ultimately, you weren't prepared to give me a weighting in relation to it, and you're satisfied with your answer. But then when I draw to your attention that when you signed the statement of common ground, it said significant, you immediately said, yes, I'll give significant weight to it. So my question is actually one which goes to your professional credibility, I'm afraid. Why is it you could tell me, having sight of that it gets significant weight, but the previous answers you couldn't tell me, trying to be helpful to the inspector?
Yes, understood.
What the weighting would be? Why?
Yeah, because we're focusing on the northern part of this site. I understand this comes into it, but this is not something that I've brought out in my proof. It's something that we've agreed upon in the statement of common ground, and I've essentially left that there.
Yeah, but you're giving evidence on the planning balance.
Yes.
So until I'd drawn that to your attention,
So
what weight were you giving it in the planning balance? Until I've drawn that to your attention, what weight were you giving it in the planning balance?
I would have given it, it's a benefit. It's a beneficial. Yeah.
Because your proof does deal with it, doesn't it? You turn to paragraph 61.
Yeah.
End of paragraph 61. I4, the provision of market housing moderate weight, the provision of affordable housing moderate weight, and limited weight to the provision of open space. So you're giving limited weight to this. You've just told me significant, having previously told me you couldn't give anything.
So I think that provision of open space, where in the proof, is actually relating to the provision of open space in the urban part of the site.
In site A?
Yes.
Okay. But site B, you stand by what's set out in the statement of common ground, yeah?
I'm happy with that, yes.
That same paragraph tells me you're giving the provision of affordable housing moderate weight. You see that?
Yeah.
Let's have a look at what the statement of common ground says. 6.13. There is a significant need for affordable housing within the borough. Delivery of 40% affordable housing is proposed in the appeals scheme, complies with the requirement of policy SP10B and represents a social benefit to which substantial weight should be given. So can you explain to me what it is that when the statement of common ground is signed, you've applied your mind to giving it substantial weight and you're diminishing it when you're writing a proof of evidence which seeks to argue against the appeal being allowed? Why would you do that, Mr. Scott?
So we're talking about 3.3 part 2, right? Of my...
We're talking about this paragraph I just read in your proof,
Yeah.
61, which says the provision of affordable housing gets moderate weight, and 6.13 of the Statement of Common Ground in the agreed bit, which says provision of affordable housing should get substantial weight. So I want to know, and this is not the extra over, this is the provision of affordable as a whole. I want to know how it is that in the Statement of Common Ground we get substantial weight, in your proof you've dialed that down. And my question was, are you case making in the proof of evidence, or are you giving your professional judgment?
I need to just go back to my the Statement of Common Ground. Bear with me.
613.
So in the Statement of Common Ground, you're saying I say it's, well, you're saying it's agreed that it's significant,
Substantial weight.
substantial weight.
613.
Okay, I agree. There's a difference.
Yeah, why
Yeah.
have you dialed it down? Are you case making, or have you pointed some factor which justifies changing your mind? Or has somebody asked you to turn it down?
I think, given the fact that it's meeting a policy requirement, it has been toned down because it's not delivering more benefits in excess of the 40%. So I've just put it down as it's a affordable provision that's policy compliant.
It's still 4 out of 10 of the homes on this site will meet a need. So you think that because it complies with policy, that you then give it diminished weight, do you?
I don't give it diminished weight, no.
Well, you have diminished the weight. That's what we're talking about. Or would you want to change your proof?
Well, I can't answer the question.
You can't answer the question. Okay. Final question, if I may, and obviously weighting these factors all for the inspector, so some things are of limited utility by cross-examination. Can we turn to paragraph 54 of your evidence? Final question. This is how you approach the matter. When the inspector comes to look at the section 38.6 balance, and indeed the paragraph 11 balance, he has to ask himself, firstly, is there accordance with the development plan taken as a whole? Do you agree?
Sorry, bear with me. Okay. Right, the reference on the proof of evidence.
It's going to be paragraph 54 I'm going to take you to.
54.
On hard copy page
Okay.
19 is where I'm going to take you to.
Yep.
But before I do so, I want to make sure we understand the ground rules. When the inspector comes to look at the judgment before him, he has to assess the 38.6 balance, doesn't he? I.e., is this in accordance with the development plan as a whole? Does it conflict with the development plan as a whole? Agreed?
Yep.
And that requires a judgment, because you may conflict with some policies and accord with others. You may conflict with parts of policies and accord with others. It's an overall judgment you've got to form, isn't it?
Yeah.
And you form the judgment that we don't comply with the development plan taken as a whole. Agreed?
That's right.
Having done that, you've then got to see if there are other material considerations to see if a determination other than in accordance with the development plan comes forward.
Yeah.
And that's where, if you've formed your judgment, the benefits come in. If you form Mr. Ross's judgment, the harms come in. Yeah? Okay. But what you are assessing is the scheme as a whole, isn't it,
Yes.
for that exercise?
Yeah.
What you're not doing is you're not slicing off that part of the scheme which is over and above what the allocation says, are you?
No.
Because you've got to look at the benefits that arise from 112 dwellings. You can't just look at the benefits from 12 dwellings, can you?
No, you can't just look at them as 12 dwellings, but you can look at what they add.
Yeah. Well, how? If I've got to weigh the planning balance to see what the benefits of the scheme as a whole are, doing the legal test here, how does it help me to know what this separate exercise would be of separating out what 12 dwellings or 15 dwellings or 94 dwellings might be? How does that help me when I'm judging the overall planning balance?
Well, we're talking about key considerations of landscape and character, and I think they're quite sort of big ticket items in the when you're considering the policies in the round.
Look at your paragraph 54. No identification of specific benefits arising from the additional 12 dwellings. Economic benefits will still be generated from 100 dwellings. You are severing out, for some reason, whether there's any extra benefits from 12 dwellings, and you told the inspector it's not much. I just want to know how on earth that informs the overall planning balance, having concluded whether the proposal accords with or doesn't accord with the development plan. So having done that, and you conclude it doesn't accord with the development plan, how does just considering the 12 dwellings help you? Or is this another exercise in advocacy?
We have to consider the additional 12 dwellings because it sits above what the policy says. So that's relevant.
Yeah,
so
I'm sorry. But the question is what you feel is the planning balance. And what you feel is the planning balance is not the extra 12. It's the totality of 112, isn't
yeah,
it?
I would agree, yeah.
Yeah. So the question you should be asking at 54 is, what's the extra benefit that arises from the scheme? Yeah?
Yeah.
Not what the specific is from the 12. Agreed?
No, but it helps. The exercise helps to understand.
So where do I see in your proof where you weigh the benefits of the 12? So 112 rather. In this section of your proof. I assess the benefits of 112 dwellings, ... So I'm asking the witness, not you, Mr. Henderson. Yeah, but we're in cross-examination, and it's not from a learned friend to answer the questions. I'm delighted if I want to cross-examine Mr. Henderson. Let me help you, Mr. Scott, rather than prolonging the agony. Paragraph 42 tells us, if you look at the statement of common ground, there's some benefits from construction and household expenditure.
Yeah.
We've then got paragraph 53, little supporting evidence that addresses local business needs or wider opportunities for development. 54, there's no identification of the additional benefits arising from 12 dwellings. Economic benefits would still be generated from 100 dwellings.
Yeah.
Matters identified by the appellant in the planning statement are also featured inclusion of council tax revenue. I don't think that's appropriate. And then 56, given these matters, I afford the economic benefits in totality limited weight. If the contributions from the additional 112 was identified in isolation, then this benefit will be very small and I would give it very limited weight. The
Yeah.
best that you can point to, I would suggest, is that in 54 I say economic benefits would still future tend to be generated from 100 dwellings. Being very generous to you, you might be working 100 dwellings into paragraph 56, which is the point my learned friend might seek to re-examine you on. But where do you assess the effect of 112? Which was my question.
I mean, 112 is taken into consideration in the round, and that is concluded in my planning balance. So that is considering 112.
You see, if you turn over to paragraph 58,
Yeah.
58, you do in the next section, in the social section, assess the effects of 112 dwellings, which you ultimately give moderate weight to. But in the economic section, you seem to sever it out. I just don't understand why.
Yeah. Okay.
With hindsight, you might have rewritten this section. Is that fair, Mr. Scott?
It's possible, yes.
Yeah. Anything else? So, would you just give me a moment, please, sir? Yeah, sorry, it's a point of clarification. Paragraph 46.3.1, just to clarify, because I don't think we do disagree. Third sentence of 46.3.1, where you say, even if the appeal site itself is not considered to be countryside, which I agree with in itself, you're there saying it is not countryside in policy terms, but it is countryside in its physical appearance. Is that what you're saying?
Yes.
Yeah, good. That is what we thought. So thank you, Mr. Scott. Nice to finish on a moment of amity. Thank you, sir.
We got one slightly, there we go. So yes, Miss Hendon, if you're happy to go through re-examination.
Yeah. Well, I'll give it a go. Okay, there we go. Good. Go back to your proof, please. Paragraph 56 that you were just looking at. First sentence. Given these matters, I afford the economic benefits in totality limited weight. When you say the words in totality, how many dwellings are you referring to?
112 units.
Thank you. Right, the plan balance exercise. Let's start with your economic benefits. You've told us your paragraph 56, you afford those in totality limited weight. So add that to your balance. Go over the page to your 61.
61.
Yeah. You tell us that you've given your market moderate weight. Add that to your balance. Okay. Affordable housing. Let's go with the statement of common ground as substantial. Okay.
Yeah.
Stick with open space. Site A, you've told us and you've clarified that's limited weight. That's your 61. Yeah.
Yeah.
Add that in. Site B, you've told us and you've clarified, you deal with that in your 59 and you've clarified in respect to the statement of common ground. You give significant weight to that. Add that in. Turn over the page, please. Your environmental benefits, we get in the round your 66, you see, paragraph 66, your conclusion there. In the round you have all those matters limited weight.
Yeah.
Add that in. Okay, go back to the section 38.6 exercise. You've already told us there's conflict with the development plan read as a whole. Look at the list of the shopping list that we've just been through.
Yeah.
How do you strike the planning balance in light of that list, please? What do you say the outcome
So we're on 30. Was it the list is on 30?
Yeah, the list of benefits we've just been through and the weights that we've just
Yep.
given them. Yeah,
Yeah.
strike the plan balance for me. You've got conflict with the development plan. you've got those benefits on the other side.
Yeah.
What's the outcome of your plan and balance, please?
My view is that they don't overcome the harm to the LLV and the character of the area and the countryside. So,
Thank you very much. Hold on. Thank you. Sorry, the microphone.
You happy with the cross-examination? Are you happy they're nice and quick, clear and easy? We are coming up to 12 o'clock then. Do you want to press on Mr. Williams, examiner in chief, or do you want to break here? What's the thought from the parties?
I don't mind. We'll need lunch before cross-examination, so it's really up to something to start before.
No, I'm happy to get examination in chief under our belts and then perhaps break at 1:45 if that's acceptable, sir. But equally recognise people's blood sugar levels dip in different ways.
And then Scott has to quickly turn around from having given us evidence to looking at the conditions as well today, but perhaps concluding soon might give him that opportunity, as well as managing the lights and everything else online. Okay. Right, well, let's get the examination in chief underway then. Yeah, well, chief, evidence in chief prior to breaking for lunch. Have that lunch, and then I don't think we'll get any further than that with the cross-examination time, because you got in there, but it gives you plenty of time to get through that if you want to. That's fine. No.
Yeah, I mean, if things go dramatically quickly, we can revisit that. But my anticipation is we're finishing Mr. Williams today and then drawing stumps. And so your need for this witness for examination in chief, I think, his proof, his rebuttal, his appendices, and also Mr. Kirkpatrick's proof of evidence, perhaps. So to introduce you to the inquiry, Mr. Williams, are you Andrew Williams?
I am.
That's a relief. Are you a qualified urban designer, chartered landscape architect and founder of and director of Define, a town planning, urban design and landscape architecture practice?
I am.
Do you tell us about your career a little bit at 1.1.2, and you tell us about your current projects at 1.1.4? Do you tell us that you regularly act for a variety of different clients, and at 1.1.6 do you tell us about your master planning experience, and at 1.1.7 your familiarity with the relevant guidance?
Correct.
Thank you. You then tell us at 1.1.8 your position in this inquiry. What has been your role in relation to this particular scheme?
Yes, I was instructed in May 24 to review the then application, and that involved me reading the background documentation, going to visit site, including all the viewpoints, and then accepting the commission to carry out that audit, and in due course then defend the appeal.
When you're in that situation of being instructed on an appeal when you've not dealt with the application, how important or otherwise is a site visit before accepting commission?
It's critical, and as a matter of course, and I probably get a request to do that sort of role every few weeks, I say I need to be instructed to review this properly, go to site, and then I will make a confirmation position in respect of whether I can support it or not.
Thank you. Paragraph 1.1.11, could you read that out, please, and then confirm or otherwise whether you stand by that, please?
Yes, certainly. Finally, I confirm that I'm aware that my duty is to the inquiry to provide my untrammelled professional opinion. Accordingly, I confirm that this proof of evidence is true and has been prepared and is given in accordance with the Landscape Institute Code of Practice. I confirm that the opinions expressed are my true and professional opinions, irrespective of by whom I'm instructed.
Thank you. I've got a few points to ask you in examination in chief, if I may, Mr. Williams. First point, dealing with what is before the inspector. Can you take up, please, core document 5.18, which I've now reminded myself to scribble on, which is the parameter plan.
Yes.
And could you just talk us through, please, the parameter plan, both north and south of Kenward Road, but particularly north of Kenward Road? What's it showing? What should we take from this?
Yes, certainly. And reading parameter plans and understanding parameter plans in this context is obviously critical at an outline stage to differentiate really what we're dealing with and what we should be assessing. The legend on a parameter plan is really important, and the coloured lines are really important. And a high level point here is the solid orangey salmon fill, the light green fill and the dark green fill. Those are land use hash residential for the orangey colour and different forms of landscape for the different colours of green. And it's clear in the definition of what those should include. And they're the maximum extent. And that's one of the key roles of a parameter plan, is to set out the maximum extent. Now, beyond that, and as you look in more detail at the parameter plan, particularly to the north of Kenward Road, there's further notation on the parameter plan. It's evident where the vehicular access point is, and indeed that's a matter of detail, so there's a separate application drawing for the detailed access. Then there are indicative components, and those indicative components include the primary street, indicative alignment, and it also includes the planting corridor, indicative alignment. Furthermore, it includes the north of Kenward Road landscape and open space within the residential land use, which it dictates with a dotted green line and the letter C. Now, all of those are indicative, and they're indicative for a good reason, because they are within the core of the residential area. And what's critical in that regard of the parameter plan at this stage, which is why my evidence and my rebuttal deals with this in this way, is to allow a degree of flexibility to enable the reserve matters application to come forward without unnecessary restriction on the precision of where those items take place, but the principle being enshrined. That leads to the best outcome through the RM process. And then further to the south of Kenward Road, yes, we've got the blue asterisks for the drainage feature, broad location. We've got different letters relating to pedestrian access, children's play, recreation area, and the dark green that relates more to biodiversity and habitat enhancement.
Let's just pick up a couple of points on that, if I may. Firstly, we have on the north side of Kenward Road the vehicular access, which is marked with a blue circle, and then to the north of that we've got two little grey circles. If the inspector goes to site, and indeed we've looked at pictures of the site, what is the existing agricultural access? Is it a field gate? Is it wide? I think what is it?
It's just a field gate for ongoing agricultural access. So that's how it will be maintained with a field gate.
So, in future or at present?
At present, it's a more wide open access point, but it will in future be a field gate to enable those agricultural activities to take place, particularly the fields to the west and to the north. Thank you.
You identified in relation to the primary street and the indicative alignment, the terms indicative. What do they fix at this stage in your judgment? Do they fix width?
No, they fix the principle.
Do they fix the alignment?
They don't fix the alignment, they fix the principle.
Yeah. If you look at the salmon notation, land use residential, it says this, including front and back gardens, internal circulation, utilities, parking spaces, SUDs and landscaped areas. What's meant by landscaped areas in terms of the salmon area?
Well, features such as the pocket park with the play, the landscape corridor that we're talking about, is essentially allowing that flexibility for that element or that feature of the application effectively to align where it needs to, which you can determine through the reserve matter stage. And you can only determine with precision at that stage.
Thank you. Let's just look at the differences between yourself and Mr. Kirkpatrick on the north side of Kenward Road. We know Mr. Kirkpatrick thinks that the east area of sort of light green should be thinner, the west should be a little bit wider, and the arrival area should be a little bit deeper. What are your thoughts, Mr. Williams?
Well, the eastern band, actually, when you overlap the route protection area, there's really only a couple of metres or so that you could save from that boundary. And I have, in the course of my instruction, interviewed is perhaps too formal a description, but had discussions with the scheme architect and the scheme landscape architect. And it's clear that their view here was just to defer sensitively to that boundary because residents existed beyond. They also recognised the benefit of that circular route for recreation. They also recognised that it's quite a high hedge and you don't want to position residential properties too close to that to create that tension that sometimes exists with pressures of overshading, and it's quite a considerable hedge feature at the moment that could be at pressure if housing was positioned closer. So I support the parameter plan where it is. So there's a slight difference between myself and Mr. Kirkpatrick in that sense. We're agreed on the northern boundary.
Well, hold on, before you leave the east boundary, you mentioned a hedge. Is it a substantial hedge or a relatively insubstantial hedge?
No, it's a substantial hedge, yeah.
Thank you. Is there any water body in that eastern boundary?
Yeah, there's a drainage channel, and so access to the drainage channel is going to be important as well.
Is there any need for maintenance of those two elements on that side?
There is a need for maintenance, yeah.
Thank you. Sorry, you were going to take us to the northern side.
Yes, so the northern side we're agreed. Mr. Kirkpatrick's supportive of that approach. And then to the western boundary, there was some discussion under cross-examination as to what value adding some additional metres separation to the west, where would that be experienced? And Mr. Kirkpatrick suggested a reasonable distance to the south-southwest in terms of views. I don't agree with that when going to those views, and we can do that if we need to later. There's a minor difference to the western boundary, and there's a minor difference to the size of that entrance arrival space that Mr. Kirkpatrick would like to see slightly larger.
Let's just deal with the western boundary. We know if you look at the illustrative master plan, you can turn to that. Is that 519?
Yes,
illustrative master plan. That within that western boundary, in an illustrative fashion, it's shown essentially as there being two new planted lines of trees. One's a little irregular, one's more regular, to the east of the existing hedgerow. Is that a dense hedgerow or an insubstantial hedgerow in that vicinity?
Yeah, it's pretty dense, yeah.
So the ability to be able to soften views looking at the approach from the west insofar as you would see it, what do you say about the effectiveness of the western boundary in terms of the parameters plan as proposed?
Well, I do agree with Mr. Kirkpatrick in that regard, and that there wouldn't be any visibility of the scheme from the west through those features, and largely because of the polytunnels that exist.
Imagine, if you will please, the appeal scheme is brought forward in broadly the same way in terms of these areas on the illustrative master plan, and you are approaching on horse, cycle, foot or car from the west, and you're looking towards the entranceway. What would you see?
You would see, the first thing you would see is the open space, the site access, the trees aligning the open space, and behind that would be buildings set back 30 metres or more from that road, Kenward Road.
Is it an appropriate design objective to hide those buildings?
It's not appropriate to try and hide them. This is the village, and the conservation area is very clear, actually, in approaches to the village. It describes the nuances of how you experience the entrances to the village. I can give you a quick reference to pages 25, 26, 28 of the conservation area appraisal. It's entirely aligned with that. You experience an entrance space and you experience the visibility of buildings. So I write in my evidence, I find it slightly odd, the desire, the apparent desire, although I think it came through cross-examination quite that strongly, but the apparent desire to try and hide buildings when they're within the settlement and they're creating a new entrance to the village. I don't think that's aligned with the character of the village, and I think the approach taken is correct.
We also know on the south side of the of Kenward Road, on the parameters plan, we've got an area which is shown as being part of landscape and open space with a blue star on it, which is said to be the SUDS. First of all, is that a broad indication that there's going to be a SUDS design in a star shape, or is it something else?
It won't be a star shape, no, it will be a multifunctional SUDS basin, varied gradients as you'd expect in modern SUDS design.
Will it be a permanent water body?
It might occasionally have water at the bottom, but it certainly wouldn't be permanent. It would be multifunctional. There'll be a great period of the year where it would be an open landscape space.
And we know from the highways plans that there's a proposed pedestrian route through this area. Is it intended to be accessible?
Certainly will be accessible, yeah.
So in terms of the arrival experience at the settlement on the western side of the appeal site, by which I mean the red edge, what would you say, appropriate or not appropriate?
I find it wholly appropriate. I find it will create that entrance space and get the right balance between sense of arrival, landscape and space that's not abrupt, but with visibility of built form.
And in terms of the precise details of how that's brought forward, is that for determination now, or is that for a future point?
It's for reserve at a stage, informed by the principles that are bound into the application, and it has to, of course, be in accordance with the parameter plan in terms of where development sits in terms of land zone types.
Thank you. The illustrative layout, what's that role? What's its role at this stage?
Yeah, its role is actually very clear in my mind. Firstly, I should say, of all the hundreds of schemes I've been involved in, the illustrative layout at outline stage has never been realised in exactly the same way at reserve matter stage. There's a really important design process that happens post-outline. Its role is to give you an indication of how the principles that are applied for and the accommodation being applied for could fit within the site. And inevitably, depending on the scale of the outline application, that can lead to some very detailed discussions. So its role has to be kept very clearly in mind. And in this case, it is exploring how a housing mix that's set out page 52 of the DAS, how that housing mix could fit positively, sensitively, within the parameters that have evolved through a landscape-led process.
Thank you. In relation to your page 13, please, so the next page across which you show the illustrative master plan, you take out what's said to be the layout principles plan, which is taken from the design and access statement.
Correct.
Page 49. And you also tell us in your evidence that the inspector could, if he wished to, seek to impose a condition bringing forward the principles of the layout principles plan. Does he need to?
I don't think he does, and as I've said before, the role of the reserve matters application is a really important exercise to get the detailed design right, and you have to tread very carefully in the level of control at outline. And I've done this actually myself on outline schemes that we've done and then gone on to produce the reserve matters. It's very easy to go too far and later regret how far you went because it closes down some design opportunities. It's a fine balance. I've suggested as a condition, there's no right or wrong actually on this point, but given the level of concern as the degree of the fixture in the parameter plan, I suggested that this could be conditioned. And if so, it picks up these visual filters, the blue arrows, it picks up where more detached built form happens around the edge. It identifies where key landmark buildings should exist. It gives confidence over the degree and the robustness and depth of the internal landscape. It controls the degree of car access to those frontages with the landscape. They're all principles, so again, they're not tying exactly where those solutions take place. So I'm entirely comfortable with the condition. I don't think that would be inappropriate at all. My instinct is probably unnecessary, but it's there as a degree of comfort if deemed necessary.
So, when looking at the issue of density, one needs to identify the net developable area and the number of units which are proposed, and then you get a mathematical outturn.
Correct.
Does that tell you anything in relation to plot coverage?
Not directly, because there's so many other things that a scheme has to include. It has to include roads and streets and landscape spaces and play areas. So a direct association in the way that has been made is a very crude and inaccurate yardstick. So it's not one that I would use.
So we knew that Mr. Kirkpatrick set out an exercise of looking at the overall net developable area,
Yes.
and just as a matter of maths, working out that came out to, he said 200 square metres, or we put 166 square metres, 167 square metres as the difference between the net developable area for the appeal scheme and for the allocation if it is exactly 100 and exactly 13 dwellings per hectare. That additional site coverage of 200 square metres, does that make any difference?
No difference at all. You will not notice it. No, I mean, it's less than 0.5%.
Would a density of development being increased by 12% in principle make a difference?
The increase in density from 30 to 33.4 is really, really hard to notice. I don't believe you would notice that distinction.
Now, with the revised wording of the reason for refusal that Mr. Kirkpatrick put forward yesterday, he suggested that when you cross over to the other side of the river and you're looking from the charmingly named Venice Park northwards, that there would be a more dominant effect from 112 compared to 100. What's your thought about that?
It will not be perceptible. It will not be perceptible. The difference between 30 dwellings per hectare and 33 from a viewpoint at that distance, you will not see the difference.
And he suggested that the width of the western boundary and the increased area of towards the entranceway would help to mitigate the effect that he considered to be more dominating from that vantage point. What do you say about that?
I just don't agree, and I think I think as you suggested, it is best experienced on site to stand there and look and get the sense of scale. It is quite distant. It's got an awful lot going on in the foreground in respect of the mobile homes. I cannot imagine in any way that you will notice that difference and need any greater width mitigation. I mean, primarily because you wouldn't see the difference between 30 dwellings per hectare and 33 from that distance. But the western edge is robust in terms of the depth of planting anyway.
In terms of density, does it depend upon how big your plots are and how they're divided?
It really does. It really does. The housing mix is indicative. It's very likely to change through discussions on RM. That's a key factor in what the density number actually turns out to be. For obvious reasons, we all talk about density in dwellings per hectare, which is an inexact tool. And so if the housing mix changes, the ability to accommodate a number of homes changes as well. So it's absolutely right and proper to allow space for those discussions at RM to take place.
In your rebuttal at Appendix 1, and you produced a better copy of it for the inquiry, you've looked at Mr. Kirkpatrick's points in his evidence, and you've sought to characterise them as being matters which apply to both 100 and 112 units, matters which relate to the outline stage only, and those which you consider relate to the reserved matters stage.
Yes.
Let's just break those down. In relation to reserved matters, what do you assume, or what would you invite the inspector to assume when viewing an outline application which is subject to a parameters plan?
Well, I would assume that, well, more than an assumption, I know that what happens if that's permitted, then there's a separate application at reserved matter stage for layout, scale, appearance, landscape, and they will have different types of conversations with officers and stakeholders than you do at the outline stage, and the layout will change and evolve with those discussions, and that will be affected by an agreed mix.
And in terms of detailed landscaping, we were told, it's paragraph 25 of my learned friend's opening, that the local planning examining inspector considered that landscaping should be an integral part of the area A of the site for housing, both around its boundary and within the development itself. Is that something that would be a matter assessed at reserve matters?
It will be assessed at reserve matters in how it comes forward, how it's realised, but the principle is enshrined within all the material within this outline application, the parameter plan, the illustrative layout, the layout principles plan. I cannot conclude at any point that internal landscape is not accommodated centrally within the design rationale for the outline scheme, but absolutely the detail of precisely where, precisely how, the specification of the trees, all of that is subject to reserve matters. And for example, a key factor there will be discussions with the Highway Authority on adoption standards. Often that's not picked up at outline stage, and that's a case of where you can be too precise at outline, get into section 38 discussions, and something that you're exactly precise on can't actually come forward in that form.
The fifth paragraph of the site allocation identifies that landscape and visual assessment impact assessment should inform the overall scheme.
Yes.
We've heard today that that means the overall scheme when it comes forward. To what extent would you expect the landscape and visual appraisal process to inform the final reserve matters?
Well, it certainly will. It will be more fine grain in its analysis of how that comes forward, because it will be part of a reserve matters process with the other matters of layout, and they're knitted together, and so a finer grain approach to understanding what, for example, those internal landscape corridors need in terms of tree species, variety, how it accommodates climate change, all those discussions, drainage, highway adoption, visibility displays, that all shapes that whole reserve matters application package.
And to what extent would objectives such as minimising effect upon the Green Sands Ridge in landscape, visual and character terms, to what extent would those be factors that will be had regard to at that stage as well as the outline stage?
Oh, really important. So for where I've been in this situation before with very similar circumstances, we've changed the specification of trees in these corridors to have much more of an impact up front. So they might be semi-mature, 20-25 centimetre girth, 6.5 metres at planting, 12 metres at 15 years. Those are decisions that you can make at RM stage. It's not closed down now.
Thank you. And then finally, process. I'll ask you the same question I asked Mr. Kirkpatrick, but in a non-leading way. Have you experience of rotten LVIAs and rotten DASs which lead to a good scheme?
I have. They're very rare because of the level of attention LVAs and DASs have, but I have. Probably more a few years ago, but definitely, yeah.
And have you seen very good LVAs and very good DASs which lead to rotten schemes?
Yeah, I'm not sure I'd use the word rotten, but I'm very, very firm in our practice of asking everyone the question, so what? The outcome should not be a good LVA, LVIA, DAS. It's the scheme that comes forward, and how is that shaping the right scheme? So certainly that can happen, and the attention is on the quality of the scheme, not just at outline stage, but putting the right mechanisms in place to inform the reserve matters.
So up to this point in the process, mindful that we're only at stage 1 of the consenting process, up to this point of the process, you have not been involved, save for the appeal process, but how have you considered that LVA and LVIA work has informed the scheme that's before the inspector?
Yeah, so I've gone through the DAS, I've gone through the LVA, I've spoken to the respective parties. It's very clear to me from those discussions that the inclusion of landscape as a topic in modelling housing and changing the shape of the scheme has taken place from the outset. It's evident in the DAS. It's probably worth a quick flick. I won't dwell too long because these pages have been looked at before.
Remember this one, 5.4.
Yes, CD 5.4, starting with page 24. And page 24 is just the title, Design Evolution. We went there before, so I won't dwell too long. Page 24 really just sets out the 3 options, and these are potential design strategies. It's a discussion, and there's a variety of options: north only, 25 units south, 100 north, 125 north. Option 3 was taken forward, and you can see that on the following page. It's clear in refining the proposals. and you can see from the left-hand image that's within the vision document, this is, at this point, the LVA starts modelling the scheme.
Well, just before you leave that, go back to hard copy page 24, PDF 26.
Yeah.
The suggestion was made, well, they're quite similar, these schemes. What's your thought on that?
Well, they're similar in the sense that they're concentrating development to the north of Kenward Road as per the policy emerging, and bearing in mind that this is before the policy, this is shaping the policy. So there's clear ambition for what takes place to the south and what takes place to the north. But there's still variety on, these are high-level decisions as to where development takes place. So I do see them as initial design strategies, that's what they're there for. And clearly there's a high level, okay, we're going to go with option 3. So there's a clear decision made as to development only north. And obviously I wasn't involved at this time, but I understand that was informing the development of the policy for the site. It wasn't reacting, it was shaping.
Okay, so you wanted to take me to the next page, page 24.
Well, just to point out, and again, this is, I won't try and describe everything in these plans, but just from an LVA perspective, this is where modelling of built form and modelling of internal and structural landscape starts to take place as a tool, not as a way of saying this is exactly the impact, but trying to understand where internal and external landscape should take place to have the maximum benefit to assimilate this development into the settlement structure. And you start, therefore, to see on the eastern side the inclusion of internal landscape corridors with minimal driveways over. That's informed by the pre-app process. But you can also see that that development form is quite orthogonal in its layout, and we are talking about illustrative layouts, so we have to keep in mind. But you can see it's quite orthogonal. There are terraced units within that. If you flick on then, sorry, I should point out with the LVA hat on, if you look at the refinements that are listed to the left-hand side of that page, increasing the landscape boundary to the north. So that was an early design decision, refining the eastern landscape strip, creating a semi-formal landscape arrival space, which you can see on the eastern side of the scheme to the north of the access. A central green, relocation of the central green southwards, and you see that as a stepping stone away from that arrival space. Western frontage with a landscape corridor, eastern frontage flanked onto the retained hedgerow. So you can start to see that landscape is shaping this scheme as it evolves, as one would expect. If you move on then to page 27, there's a stepping stone again, a further level of refinement informed by the LVA process. There's a reduction from 125 to 112. That's a product of understanding the typologies that could sit...
Just take a step back. Which page are you on, Mr. Williams?
Sorry, I missed that.
Which page are you on?
Oh, beg your pardon, 27.
27, thank you.
And so the eastern plan is showing the refinements that are made. There are looser development blocks, less orthogonal. The housing typologies are more semi-detached and detached, responding to local character and discussions that are made. The internal landscape has changed its shape. Again, that's come through that modelling iteration. There's a much larger entrance space that's following from pre-app discussions. And and you can see the eastern boundary is kept as it is. So overall, you can see that this is evolving through that process. It's not, design evolution process is not strict in saying, right, that report will change it, right, that report will change it. It's an ongoing, fluid series of discussions, which from my discussions with the scheme architect and landscape architect took place very regularly and was informed with the discussions with the authority. And if you flick on from there to page 32, on the eastern side of the image, you can see the landscape framework. The design principles are enshrined there. That simplifies and summarises the landscape principles in a framework, and you can see there the variety of spaces that are identified with the internal and boundary landscape corridors, but also those key arrival and entrance spaces that are discussed. And that goes forward to page 39. Page 39 is aligned with Appendix F of the LVA and sets out more detailed landscape principles, which I won't read out, they're self-evident, that then moves forward at page 49, the layout principles plan, with those features being listed as I've set out in evidence and is self-evident. So to suggest that this is not an LVA landscape-led process is wrong, absolutely wrong in my view. And just a word on semantics, LVIA is an LVA that takes place in an environmental impact assessment procedure. So just for those that perhaps aren't aware, that's the fundamental difference between the words LVA and LVIA. LVIA needs to make a conclusion on its significance of effects. LVA doesn't because it's outside the ES process. So the LVA process here, in my view, has been influential, it has been fluid, it has shaped the scheme. You do not and would not expect to get that full story in the end product LVA report. That is making a succinct summary on LVA process, assessment of landscape visual effects. The DAS does chart that process in the way that I've just trotted through.
Could you take a, I appreciate it's not a document that I took you to, but do you have Mr. Ross's proof of evidence to hand, please?
Yes.
And when you get to it, it's paragraph 410.
Yes.
And this is in the section describing the pre-application application process, and he can be asked questions about what happened before you were instructed. But he says, a meeting with officers eventually offered in May 2024, albeit a fee of £1,600 was sought for the meeting to take place. Upon the receipt of the additional sum, the Council confirmed it would also provide the appellant with the review of landscape and visual matters relevant to the application it had procured from Peter Radnell Associates. Document produced 2 months previously, not being made available to the appellant, ... To expedite matters, the fee was paid. I understand officers explained that they took issue with the landscape impacts of the proposal, irrespective of whether this was a position supported by the Peter Radnell Associates report that the Council had procured. You've seen Mr. Radnell's appraisal now,
I have.
as indeed have the appellants. Does Mr. Radnell's appraisal raise similar points to those of Mr. Kirkpatrick?
No. The conclusion is that it's in accordance with the principles of clear, well presented and compliant in the main access to good practice. There are queries and reservations that in the main are not driving at all as a difference between the allocation and the appeal scheme. Agreement of viewpoints, understanding the technical element of the vision material, not having a county level LCA, and I've responded to those details in my main proof of evidence. But
Sorry.
yeah, overall the summary is there. It's well presented and compliant.
Criteria 5 of the policy SA248 of the allocation talks about the housing element being informed by an LVIA. It doesn't say an LVA. Does Mr. Radnell suggest in his assessment that there should have been an LVIA?
No, he doesn't, and he wouldn't for the reasons I've set out. That's a formal step to an environmental impact assessment chapter.
Do you need an LVIA in your professional judgment to form a view about the acceptability or otherwise of the scheme at outline stage for these proposals?
No, because the only difference is it would conclude a statement of significance of effect.
Thank you. And then the final issue I want to turn to is the issue of density. A scheme of 30 dwellings per hectare of 100 units on the site. We have Mr. Kirkpatrick's view about how different that would be from the settlement. What's your judgment about how different that would be from the rest of the settlement?
Imperceptible. The difference between the village and 30 dwellings per hectare is the big step. There are other developments in the village that are over 30 dwellings per hectare, but in the main, it's lower than that. So the biggest step of how this allocation would relate to the settlement is the decisions that have already been made to be around 30. And as I mentioned in Chief not too long ago, I would really challenge anyone to walk around a scheme of 30 dwellings per hectare and a scheme of 33 dwellings per hectare and say with any confidence which is which. And we do this on our study trips in our office. So it's not just a theoretical point.
So he said big difference between the allocation and the existing settlement density. Do you agree?
Sorry, a big difference.
He said there's a big difference between the allocation density and the existing settlement density. Do you agree with that?
Yeah, there is a reasonable difference. Yeah, yeah.
He says there's an even greater difference between the appeal scheme and the settlement. Do you agree with that?
Well, there's a slightly greater. It's ever such a slight increase in dwellings per hectare terms, but from an absolutely imperceptible change in character terms from my perspective.
Normally I'd say thank you very much. Would you wait there, Mr. Williams? But that's all I have for you in terms of examination in chief. Thank you very much indeed. Thank you, sir. And obviously, sir, we'll ask Mr. Williams if he wants a sandwich, but otherwise ignore him for the next hour of his life.
Okay. Thank you. That brings in the evidence in chief. Clearly no point starting the cross-examination yet, so we will have our break. Yes, Mr. Smith. Okay. No problem. We'll have a break there then for lunch, 1 hour, and then we'll come back for cross-examination. Well, thank you. We'll adjourn there until 1:30. Thank you.
Thank you, sir. Thank you, Mr. Williams.